We are now here for our oral argument in CV20-0460 BMO Harris Bank versus Espiau. As you know, or at least have heard this morning, we record and live stream the proceedings. So when you stand up, please give your name and the client that you're representing for the record. As you have seen, according to our current protocol, you'll be arguing from the podiums at your council table rather than going to the middle. You do still have 20 minutes per side, which you are not obligated to use, but you are welcome to use. And we track that, unfortunately, at the old podium. So you may have some difficulty seeing it. Please feel free to keep your own time or to move about as you need to keep track of your time, because it is your responsibility to keep track of your time. Keep in mind, we've read the briefing, we have studied the record, we've conferenced and discussed the case this morning. And with that, please feel free to proceed.
May it please the Court, Your Honor. Christopher Goodman for the estate of Dorothy Espiau, by and through the personal representative Kenneth Espiau. Mr. Espiau wanted to be here today but had a scheduling conflict. He is participating through live stream, but he did want me to let the Court know that he is very invested in this and wished he could be here. What we have here is we have four different bases for this appeal and four different bases for reversal, and admittedly, each one presents a fairly high burden. A fairly high standard of review for the appellant. But looking at the case overall, this is a case of statewide importance. It's a case where the court can provide some statutory guidance regarding Arizona's deficiency statute, and specifically in regard to a lender's good faith obligation in enforcing the deficiency statute. Now, certainly we have our sub-issues that we'll discuss here shortly, but overall, I think the lens that we're looking through in this appeal is going to be one of fairness, of reasonableness when pursuing a deficiency action, of fair market value when a property is sold at a trustee sale, and what you claim when you file your deficiency action. And I think that issue is certainly going to color the fee portion of this appeal, but I believe that it is something that affects the entire appeal. I know the court has already read the briefs. I'm not going to go through and recite all of the facts here, but it is important to consider how we got here and consider how we got into court below and how we got into court here. Now, back in 2005, Dorothy Espiau has a home in the same subdivision where this vacant lot was located, purchased this vacant lot because it was superior to her lot. It was a great lot. It was her dream to eventually build a home there and have that be her home until she passed away. Now, in 2005, those were heady times in Arizona, certainly, and the lot was purchased for $415,000 and funded through a $370,000 loan from BMO's predecessor, M&I Bank. The years passed, markets and fortunes changed. Dorothy Espiau continued to pay the mortgage, continued to hold the property in the hopes that she could develop it at some point, but she passed away in December 2015. The estate continued to try to hold the property for a couple of years, and it ended up trying to sell the property for well over the ultimate sales price in the trustee's sale, as well as slightly over the values determined by the experts here.
Once Dorothy died, did the estate have an obligation to notify her what underwriter she had done?
Yeah, there is no set time for notification for I first want to preface this by saying I was not the probate attorney in this case. And I am not a probate attorney. I do trials. And so I was brought in when this deficiency action began. But my understanding of the probate code and the probate process here was that the personal representative there was probate opened, so there was a case number in Yavapai County. The personal representative, Ken Espiau, was appointed, and he attempted to do the legwork in notifying creditors without the assistance of counsel.
Counsel, so while there may not be a requirement that the estate notify the bank within a certain period of time, isn't the statute, ARS 143803A1A, clear when it says that the personal representative shall publish notice to creditors, must give notice, and specifically says notifying creditors of the estate to present their claims within 4 months after the date of first publication of the notice or forever be barred.
Yep.
So in order to take advantage of the forever be barred portion, Must there not be strict compliance with the requirement that the representatives say your 4 months starts now?
The statute does say, it does have the word shall in it. In order to take advantage of the probate claims statute, you do have to provide notice to your creditors. You provide them of notice of their claims or potential claims, and you do, there is the magic language that talks about the 4-month limitation. And I will concede that in this case, the personal representative did not specifically say 4 months. However, the personal representative did go in with about a year and a half after Dorothy's passing, which is still, like I said, there is not a requirement within a certain time that this notice be provided, but the requirement is rather after the notice is provided to make claims. Went to a BMO Harris Bank branch, talked to the branch manager, provided the death certificate, provided the letters of personal representative, said, hey, I'm not going to be able to carry this property. We're going to end up defaulting on it. What can we do to work it out? They notified them of their claims. And this is, as I mentioned before, this is a personal representative who was attempting to probate this matter, doing mostly his own legwork. This is the notice that he gave BMO. It's not disputed in this case, this notice provided. In fact, BMO, and during discovery in this case, admitted that it was further escalated to their probate department. So I can appreciate, well, in the statute it has the word shall, and it does have the 4 months. I would point, one of the reasons why we've cited to, unfortunately, an unpublished decision, the Reed case here, which is BMO Harris v. Reed, so BMO Harris was involved in that case, is the Court of Appeals in that case examined what actions were taken by the representatives or personal representatives of the estate to notify the bank, even though it was conceded in that case that there was not the particular magic language regarding the 4 months used when the notice was given. And in that case, you had a decedent whose estate was probated in Canada, so there was no notice to courts in Arizona. You had a couple of people who were not personal representatives who were calling the bank and who were saying, hey, there might be some accounts there. We want to know how we can get that money out of the accounts. Not saying, hey, we owe a bunch of money on a piece of property and we can't carry it. What can we do to work it out? They weren't saying there's a claim or there's a debt. They were saying, can we get the money? So the Court of Appeals in that case, again, persuasive, not controlling, memorandum decision. The Court of Appeals in that case was willing to consider some of the steps that the heirs, not even personal representatives, the heirs took. In this case, the personal representative took much stronger steps. I would say there's a huge disparity in the sophistication between a bank that has a probate department and actually litigated that Reed case in understanding what sort of effect the notice and personal representative and the letters of personal representative and the death certificate and the notice that a claim will be arising because we're going to default on this mortgage. I would say that a bank like that should know exactly what's going on. But instead, what happened here is the bank waited 15...
Aren't those different communications, counsel? Isn't it different for a representative to come forward to the bank and say, your client has passed and we are in a situation where we may not be able to retain the property. What can we work out, as you stated? Isn't that different from saying, I'm giving you time-sensitive notice and you will be barred from your claims? Those are different, aren't they?
Well, I would say they're different, but the fact that they defaulted within a month or two was a pretty clear communication as to what was going to happen.
But isn't one reaching out to perhaps negotiate a different treatment of the loan, and the other is notice that we're going to take an adversarial position and bar you from seeking those funds?
It is a slightly different communication. I will say the bank understood exactly what it was. I mean, the bank sent, if you look at the complaint, I believe at Exhibit E, there is an affidavit that includes a copy of the letter that the bank sent to Dorothy Espiau's empty residence, despite having noticed that there was a personal representative and his address. Sent to Dorothy Espiau's empty residence 2 weeks after this meeting at the bank saying, sorry for your loss. We may have a claim against the estate. We want to know what you're going to do. So it was sent to the empty residence despite them being fully aware that there was a personal representative, that she had passed away and there was a personal representative appointed and the personal representative's address being known. Same thing with, ultimately, the default letter that was sent. And same thing with the notice of trustees cell. These were sent to an empty residence of somebody who passed away 2 years before. So while the estate provided notice that they were going to default on this loan, they didn't receive any other communications. Ultimately, they really didn't even know that this property was sold until, certainly we're not disputing the notice of trustees sale. We actually conceded that below, that they met all the statutory requirements to hold the trustees sale. But The estate did not know that this property was sold at trustee sale until after it already happened. Now, I think just getting to what occurred at the trustee sale and then leading up to this deficiency action is important as well. Shortly before the trustee sale, during discovery we obtained this, but shortly before the trustee sale, BMO had an internal appraisal of the property at $175,000. Ultimately, when they sold the property, they made a credit bid of $135,000, $40,000 less than their own appraisal 2 months before, and accepted a bid from a third party for $4 more. Sold the property for $135,004, despite about $295,000 being owed on the loan. They immediately sent, that's when they started sending, serving and informing the estate of what was going on. The estate then became aware there was a $157,000 deficiency action that was going to be filed. Now, ultimately, and really the only disputed fact in this case is going to be the fair market value of this property as testified at the fair market value hearing. The estate's expert testified it was worth about $270,000. The bank's expert testified it was worth $220,000, which is $85,000 more than the bank sold it for. So that's really the only factual dispute in this case. A lot of these facts are admitted and have been admitted for a couple of years now. But the appraisal in April, or the internal estimate of value in April of 2018 is important because then the property sold for $40,000 less. And then the full deficiency claim was made for $157,000. And that essentially forced the estate into litigation. I think when you get there, when a bank gets there in the real world and they've got a party that defaults on a property that is deficiency eligible, they probably assume that this is going to be somebody who's going to be inattentive, or somebody who's going to default, or somebody who's insolvent, who really doesn't care, what our deficiency claim is. In this case, the estate had asked to try to work out this loan, has tried to figure out a way to work out the loan, and heard nothing for months. Only heard that the trustee sale had occurred. Then they're faced with a $157,000 deficiency action. The estate does have assets. The estate has assets to protect. But $157,000 and a sale price of $135,000 at trustee sale was ridiculously low. The estate had tried to list the property at $350,000. It didn't sell, but it was certainly worth somewhere in that range, as the estate's expert ultimately concluded, and even the bank's expert concluded it was worth $85,000 more than it sold for. So that's, I think, where we get to the fee issue here. And we've raised two issues on appeal with the fees, and I'm trying to fast forward here because I do want to reserve about 2 or 3 minutes for rebuttal. When you consider the fee award here, the fee award ultimately was higher than the deficiency that was awarded. What essentially has happened here is the estate was forced into litigation by the bad faith of the bank, by the bank selling the property for way lower than even the bank acknowledges it was aware it was worth in June of 18 when it sold, and even lower than what the bank put forth to the court in February of 20. It forced the estate into litigation. So essentially, and then with the fee award, the estate is forced to pay for the pleasure of litigating this and calling the bank out and having the bank raise the value of the fair market value of the property by $85,000. The estate apparently has to pay $95,000 in order to save $85,000. So we've submitted that the bank is not the prevailing party when determining attorney's fees. The bank claimed attorney's fees under 4 different statutes, or 4 different reasons. I believe the trust deed, as well as the note, as well as the deed of trust statute and the deficiency statute. None of these statutes mandate that all fees should be awarded. They are all subject to reasonability. In this case, the fees that were claimed and ultimately awarded were unreasonable.
Before we get into the amount of fees, don't
Sure.
we have to look at this, the whole failure to object, Rule 60B?
Yeah.
So could you talk to me a little bit about why we would go beyond the abuse of discretion?
Understood. There was a Rule 60 motion in order to allow for a late filed response to the fee application. The facts are provided in the declaration that accompanied that Rule 60 motion. The delay from the time that counsel had a written agreement, the delay was 3 judicial days. It was due to counsel's, my illness at the time. And I can appreciate the bank's response motion saying that, keying on the fact that in my affidavit, in retrospect, in June of 2020, I looked back at May and said, well, it wasn't a severe illness because I didn't have COVID. But at that time, it was a very concerning time, I think, for everybody. And I'm not blaming everything on COVID, but certainly being a sole practitioner, losing my staff, or frankly, releasing my staff when that occurred, becoming ill before the due date of the response, and then informing opposing counsel on the morning the judgment was entered that, look, I'm going to file a response today.
But as I understand, and I just want to make sure I understand the timeline.
Sure.
And as I understand it, the timeline that was in effect, based on notice to the court, was May 19th, and your affidavit indicates that you became ill after that.
Right. We had an email agreement between counsel that I could file until May 22nd. It was not filed with the court.
Okay.
So
the operative deadline was the 19th.
The operative deadline for the court was the 19th.
Okay.
We're asking for the court to consider the response to the fee application based upon a standard of excusable neglect. And I'll point out, I believe, the Ulibarri case discusses what is excusable neglect, and it's simply not inadvertence, but it does recognize that there are certain things that arise during the practice of law, and I think this would be an example. There's no prejudice to the bank. We argued below there was no prejudice to the bank when considering the response to the motion. We think that the lower court abused its discretion in denying that motion. I will note, however, that the lower court did ultimately rule again on the fee issue in the final judgment, or I believe the final minute entry, denying the Rule 60 motion. The trial court did say, I want to assure everybody, and I'm paraphrasing here, but I want to assure everybody that I considered the arguments in the fee application and found the fees to be reasonable. Our argument, of course, is the fees were unreasonable because they far exceeded the amount of the deficiency, and frankly would not have been necessary had BMO been conducting itself fairly from the beginning and been fair to its own borrower and fulfilled its duty of good faith to the borrower. Certainly, if we had received a notice saying we owed $72,000, settlement discussions would have been a lot easier to begin than 157, especially with such a low sales price at the trustee's sale. So I think that what essentially happened here is BMO created work for itself and for its attorneys, and the court ultimately, setting aside the Rule 60 issue, the court ultimately rewarded that by awarding all of the fees that were claimed. I've identified in the response to the fee application below, and there was a reply filed by the bank. The bank essentially, in opposing the Rule 60 motion, filed their reply in support of fees. There were identified multiple time entries that were duplicative. There were motions that were conceded, or motions that even the bank admits were identical, or responses that were identical to a motion to dismiss and motion for summary judgment. But yet the bank is spending between 20 and 30 hours on each one, or preparing for 59 hours for a 4-hour fair market value hearing, and charging their borrower for the pleasure. I'm going to reserve the rest of my time. I appreciate the court's time today.
May it please the court, my name is Michael Vincent. I represent the appellee BMO Harris Bank. I was going to discuss today 3 issues: the non-claim statute, the fair market value hearing, and the Rule 60 motion. But before I do that, I just wanted to briefly touch on the fee issue and point out that the estate fought the bank at every step of the way in the underlying litigation. There was a motion to dismiss based on notice of the trustee's sale as well as the non-claim statute. There then had to be discovery on the non-claim statute. There were cross motions for summary judgment, a full-day fair market value hearing with experts, and then the Rule 60 motion. Plus, the trial was in Yavapai County, and given all of that work, the $77,000 approximately in fees was quite reasonable. Now, on the non-claim statute, this court decided this case before it was ever filed, and it did so in the 2015 case of BMO Harris Bank versus Reed. The estate tries to distinguish Reed, which involved virtually identical facts, by splitting hairs in the background regarding probate in Canada versus probate in Arizona, and this particulars of the communications between the PRs and BMO. But none of those facts were essential to the court's holding, and the court just applied the straightforward, clear statutes of ARS 34 at 143801 and 143803. Reed did not create some sort of common law rule for when we evaluate that proper notice has been given to a creditor. It just relied on the statutes. And 143801B is very specific in requiring the PR to give a precise form of notice to known creditors. The notice shall also notify all known creditors to present the creditor's claim within 60 days after the mailing or other delivery of the notice, or be forever barred. That's a very specific form of notice, and it was not provided in this case. The companion statute, 3803A2, imposes a shortened time period for the presentment of claims if you give the notice that 3801 requires. If you don't give that notice, the condition precedent is not triggered, and the shortened time period does not apply. The estate ignores the specific requirements of the statute and argues that when the PR had the communications with the bank in May of 2017, the bank should have known it needed to make a claim against the estate. Well, of course, in the abstract, BMO knew that at some point it would have to make a claim against the estate, but the question is one of timing. And you have the situation here where the decedent dies in December 2015. The PR is appointed 1 month later in January 2016, and then the PR continues paying on the loan and never tells the bank that the decedent has passed away for 18 months until May 2017. No specific deadline is given when the PR finally speaks with the bank, and then the PR continues paying on the loan for more than 60 more days because the loan didn't go into default until August 2017. So given all of those facts, when exactly is the bank supposed to guess as to when the PR thinks that the cutoff date for claims against the estate is due? The purpose of the statutes is to provide certainty for creditors and estates alike, and the estate's interpretation of the statutes, which ignores their plain language, would open the door to litigation in every case. Well, how many contacts did you have with your creditor? What did you say? That's not how the statutory scheme is intended to work. I now want to turn to some of the details of Reed because the state has made hay with the Canada probate and what the communications were. Now in Reed, there were communications from the PR to the bank. There were 4 letters that asked about the decedent's accounts, advised of the death, and asked if funds could be released. The court didn't rely on the fact that the main probate in Canada was in Canada, and so there would only be ancillary probate in Arizona. The court didn't rely on whether the word liabilities was mentioned. The court properly looked at the plain language of the statutes and held that the communications were insufficient for 2 reasons. First, the communications did not include, quote, any type of notice directing BMO to file a claim with Emily, who was the PR, within 60 days or any other time frame, given that the bank was a known creditor. And second, the court held that the letters, quote, did not state that failing to file a claim within the applicable time period would result in BMO's claim being forever barred. And therefore, in paragraph 16 of Reed, the court correctly applied the plain language of the statutes, said there was no evidence that the estate notified BMO that it needed to present its claim or be forever barred, and the non-claim statute did not bar BMO's lawsuit. Now, Reed does not stand alone. There's the estate of Travers case, which in passing recognized that actual notice is required under 143801, and there's the Montana case of Wood versus Anderson, which is the only other jurisdiction to really dig into this issue. And there, the Montana Supreme Court, in a very similar situation, held that a letter to the creditor was insufficient to give actual notice because it did not notify them to present their claim within the statutory time period or be forever barred. The court should follow Reed and Wood and hold that the non-claim statute did not bar BMO's claim. Now, I'd like to turn to the fair market value issue. And there, at the fair market value hearing, the court received conflicting testimony from 2 appraisers. One was the bank's appraiser, Mr. Lopez, and the other was the estate's appraiser, Mr. Dominic. The court made extensive findings of fact, heard testimony, and determined that Mr. Lopez offered the more reliable opinion of value. There was nothing clearly erroneous about the court's decision. The estate, in its briefs, and fixates on this bizarre, somewhat bizarre argument that somehow Mr. Lopez testified inconsistent with his own testimony. And that is absolutely not the case. Mr. Lopez testified that when he was appraising the subject property, he looked at the lots in the subdivision, which were all vacant, and he noted that they had some differences in topography and development costs, but the magnitude of the differences from lot to lot was approximately equal. Some needed maybe a little fill of dirt, some maybe needed a little dirt taken away. So he didn't make a lot-specific adjustment for development costs because they were all approximately the same in magnitude, and the actual sale values of the comparables he looked at were fairly narrow in range. That's page 182 of the hearing transcript. Now, the estate claims that somehow this means that Lopez considered all the lots to be identical, like a mass-produced car. That's not the case. And the testimony that the estate cites regarding the supposed inconsistency is actually where Mr. Lopez was, through his rebuttal report, Trial Exhibit 4, explaining that the estate's appraiser, Mr. Dominic, actually didn't correctly state the topography of the lot that he was offering an opinion of value on, because Mr. Dominic called the lot slope generally level and a relatively gentle slope. In fact, the slope was 1 foot down for every 9 feet across. So all he was saying in that testimony was that Mr. Dominic had inaccurately stated a fundamental characteristic of the property in Mr. Dominic's report. Mr. Lopez's testimony was not at all inconsistent. Turning to the denial of the Rule 60 motion, the trial court correctly denied the estate's Rule 60 motion and found that there was no showing of excusable neglect for 2 reasons. And the first is, as the court has recognized, the estate was already 2 days past the deadline before counsel ever fell ill. And the second reason is that even if you consider counsel's illness, the estate still did not show that counsel was incapacitated during the 7-day period from May 21st through 28th, such that he had shown excusable neglect. Now, I want to touch on the timeline here because it's very important. Initially, the estate's objection to the form of judgment was due May 12th, and its response to BMO's motion for attorney's fees was due May 19th. On May 11th, the parties filed a Rule 7.1G notice of extension of time, which bumped that back from May 12th to May 19th. Now, May 19th came and went, and the estate filed nothing. May 20th came and went, and the estate filed nothing. The morning of May 21st came, and the estate filed nothing, and counsel did not fall ill by his own declaration until late in the morning on May 21st. Now, the estate argues, wait, we had this extension that we never filed with the court, but opposing counsel can't grant extensions, only the court can. If Mr. Goodman and I agreed to extend our reply brief deadline, it wouldn't be effective here unless we had a court order extending that deadline. Rule 7.1G creates a mechanism by which the court will automatically approve certain extensions of time, but you still have to comply with the requirements of the rule to claim the benefit of the rule, and that was admittedly not done here. The deadline was May 19th. The estate was already 2 days overdue before any illness came into play, and for that reason alone, the trial court correctly found there was no excusable neglect. But even if you look at the illness itself and you look at the declaration that counsel attached to his Rule 60 motion, it does not meet the high standard for showing excusable neglect. COVID-19 was a thing. It was very concerning, and if I had fallen ill in Mr. Goodman's shoes, I would have been very worried as well. But isolating from other people and the public does not mean that you're incapacitated to seek an extension of time. You can sit there in isolation with your laptop and type one out. The estate had the burden of showing it was entitled to relief, and that means for that 9-day period from May 21st to May 28th, 7-day period, it had to show that counsel was incapacitated such that he had excusable neglect because he couldn't have filed an extension of time. And that data, that fact is just not in the declaration. The declaration admits that illness is non-severe and never says that he was incapacitated for that period of time. The trial court waited 9 days. It waited from May 19th to May 28th before it signed the form of judgment, which was plenty of time. The trial court correctly denied the Rule 60 motion, and it certainly does not rise to saying that the trial court somehow abused its discretion by denying that motion. In conclusion, the trial court correctly applied the probate non-claim statute. It did not clearly err when it found the fair market value of the property to be $220,000, and it did not abuse its discretion in denying the Rule 60 motion. Unless the court has any questions, that's all I have.
I think we're good. Thank you.
Thank you.
Mr. Goodman?
Thank you. I have to admit, I never thought I'd be arguing the severity of my illness before the Arizona Court of Appeals. But here we are. So let me talk first about the allegation, well, the insinuation perhaps from the bank that the debtor, the estate fought the bank the entire way. Of course the estate did. The bank went out, sold property that we had owned at a trustee's sale and sold it for $70,000 less than what the bank itself said it was worth and $85,000 less than what the bank later said it was worth. We had to fight the bank. We had no choice. That's the point. That's the point we're making in this appeal. That's one of the points we're making, certainly in the fee argument, that we were forced to litigate this case. Yes, we fought the bank. However, I will say this. If you look at the October 24th, 2019 transcript, and also the opening brief, and the communications that were included in the response to the application for attorney's fees, the estate offered to concede a lot of the points that were argued in the bank's motion for summary judgment. The bank went ahead and argued the motion for summary judgment, even though if you look at page 5 of the October 24th transcript, we say, look, we agreed to concede a lot of these points about the trustee's sale, notice, and things like that, and get down to the heart of the issue, probate claims and the fair market value. So to say that we fought the entire way, we were trying to concede points that we reasonably had to concede. However, the estate was essentially forced to fight this. $77,000 being reasonable for one deposition and a 4-hour hearing in Yavapai County. I think that, perhaps that's something that's left to the courts. Certainly, it is within the trial court's discretion. It's reviewed for abuse of discretion, but there's also, I think, an opportunity for this court to correct that abuse of discretion, and also to, it's clearly excessive, and I've identified particular time entries that are clearly excessive. Again, with the idea that that the estate fought this unnecessarily and caused all those fees, we fought this and we got an $85,000 concession from the bank. It cost us that much to get there, though, and that's what the bank's trying to charge us. Regarding the time elapsed between the notice that was provided in May of 17 and the default date or the default in August, that would be 90 days roughly. That would be the time that it took from stopping paying on the loan to the default. And the bank didn't send a default notice until January of 2018, and didn't actually notice a foreclosure or trustee sale until March of 18.
Regarding, thank you, counsel. We appreciate your argument, but your time has run.
Thank you.
Thank you both for the arguments. We will take the matter under advisement and issue our decision in due course. With that, court is adjourned.